name is Chuck Dick. I have the privilege of being co-chair of the programming committee for CalArb, and one of my double privileges is to serve as a host of this series we call California Conversations. I've been looking forward to our interview today for a considerable period of time, part because our guest, Mike Jacobs, is a personality I have had the privilege of knowing here for the better part of a couple decades. And I've really been delighted to see him transitioning his practice into service as a neutral in the dispute resolution realm. And I wanted desperately to get him to come on board for one of these interviews. We finally able to pull this off. And Mike Jacobs, let me welcome you to California Conversations. It's going to be a wonderful opportunity to have some talk back and forth about who you are and how you got where you are, but welcome, welcome.
Thank you so much, Chuck. I'm pleased to have a chance to talk with you again in this format, and I'm pleased to join the ADR world. So it's a double satisfaction.
Mike, you and I met when you were a prime figure in big law and in the intellectual property area, particularly. I remember crossing paths with you in a case where we were co-counsel. You left a very favorable impression upon me. And so I've done a little sleuthing into your background. I must say, as much inquiry as I've made, I'm not exactly sure I can trace completely. So maybe you ought to just tell us how you got into this business of the law. And in the first place, you've got a background that suggests you really could have been Secretary of State.
Well, thanks. Yes, so I did spend a few years in the Foreign Service. I went to Stanford for undergraduate, and I majored in history, particularly Soviet and Eastern European history. I took a lot of Russian in high school and college, and then joined the Foreign Service, where I was sent to Jamaica, of all places. I spent a couple of years there, and then I found a job in Washington, D.C., working on arms control issues. And the administration changed. There was much less interest in arms control issues. And perhaps more importantly, my LSAT had a sell-by date. And had I not gone to law school then, I would have had to try to replicate a pretty successful test-taking experience. So off to law school I went. I joined Morrison and Foerster right after law school. I joined the business department. The tech business in the Bay Area was just starting to boom. And so I joined the business department of Morrison and Foerster and said I'd like to be a tech lawyer. And that was kind of the start of it all.
Are you a California native?
Almost. My family moved out here when I was very young, 3 years old. I grew up in Marin County, went to college in the state, of course, went out of state for Foreign Service and for law school. And then I met my wife in law school, and we returned to the Bay Area to start our legal careers right after law school.
Mike, your academic credentials would suggest that going to Yale, for example, to law school, might have inclined you to the life of an academician. That is not the route you chose. But tell me a little bit about your thought processes, not only in selecting Yale as a law school, but deciding to really actively pursue the practice of law.
I think one thing I learned from my government service was the importance, to me at least, of having a genuine, tangible impact on the world I'm working in. My job, especially in Washington, D.C., was absolutely fascinating, but it was part of a large bureaucracy with enormous and powerful stakeholders, and the contribution I realized I could make, the difference I could make, was quite limited. And so as I was thinking about, okay, what next do I want to do? I thought, you know what? It's really great to have clients that you actually do tasks for, whose problems you try to solve. And they're very practical problems. They're very manageable problems. And so I think that helped me on this journey decide, you know what? I want to work in a law firm, and I want to work on client problems because those are real and immediate and need solution.
Tell us then a little bit about how this yearning for a business practice, admittedly in the tech sector, ultimately led you into more of a dispute arena.
It was quite a change of pace. And it's a fascinating story. And it's a story about how an individual floating on the sea gets moved back and forth by the tides of what in retrospect look like major historical forces. So I wanted to be a tech lawyer, and I actually had a computer programming training, if you will. I had taken comp sci as an undergraduate. I'd done a little computer software in high school. And so I was assigned to some software matters. One day we met with a Japanese client that was looking for representation. That Japanese client was Fujitsu. Fujitsu had decided, along with Hitachi, to develop a business of cloning IBM mainframe computers. Fujitsu and Hitachi had taken advantage of the fact that IBM had not copyrighted its mainframe operating system software. So all these companies had to do was build the hardware and copy the software, and they were a fierce rival for IBM in the mainframe computer arena. Except one day IBM decided to change its strategy and started to apply copyright notices to its operating system software. And it took a while for these companies to realize what that all meant, that, oh my gosh, we actually have to independently develop our own operating system software. And IBM caught them in copying. And in the case of Hitachi, actually did this amazing incident where they did a sting to catch Hitachi in a trade secret theft. To make a long story short, that pattern led to first a settlement agreement between, in a relevance to me, IBM and Fujitsu, and then a dispute about the settlement agreement. And the settlement agreement had an arbitration clause. So we're back in the mid 80s, and you can see the initial threads of what has led me to the present day. It turned out to be an absolutely fascinating dispute on so many levels. There was this international dimension of the emerging Japanese superpower. Back in those days, it was Japan that we feared as our commercial rival. And it was Japan as against whom the United States was asserting intellectual property as a barrier, if you will, to having our industrial lunch eaten. So there was that international dimension. There was the changing law dimension. This was at the dawn of copyright protection for computer software. The United States had just explored this issue a few years before and decided, yes, we are going to actually tweak our Copyright Act to make it clear that computer software is protected by copyright. But none of the cases had been decided yet about what that really meant. So we're litigating this case in the shadow of evolving case law. And then it was an ADR laboratory, especially for one of our arbitrators, who was an ADR specialist. He was an ADR specialist, albeit in family law. Name was Robert Mnookin, a professor at Stanford at the time, ultimately moved to Harvard. And he saw this opportunity to apply all of his ADR interests to the resolution of this titanic case, a potentially life-ending case for Fujitsu. And if it didn't end Fujitsu's life, it was likely to be an enormous case financially. IBM was seeking billions of dollars back in the day when $1 billion was a lot of money. That case comes in the door, and I'm assigned to it by a twist of fate, which is its own story. And that's how I became a litigator. I was the guy who knew a little bit about computer software, knew a little bit about intellectual property law. I knew a little Japanese through another thread of my life. And so there I was, the first associate in the IBM Fujitsu arbitration, which lasted for many years and launched me on the path that I ultimately took.
So at what point in your career is all of this taking place?
I'm a young associate. I'm maybe a 2.5 year associate at Morrison and Foerster. I have not enjoyed my transactional practice. I was not a very good transactional lawyer. And then I get this lifesaver thrown to me, and I loved it. I loved the case. I loved litigation, contrary to what I had thought. I loved the adversarial process. We were up against Cravath, Swaine, and Moore representing IBM. Bob Raven at Morrison and Foerster was lead counsel for Fujitsu. And so I was just right in the middle of it.
You had a great mentor there to show you the way into dispute resolution. Bob Raven is a legendary name in California, and I'm sure you must have picked up a lesson or two from him.
Well, in the funny way that these currents come together, Bob was, in his own way, a big proponent of ADR. In the middle of the Fujitsu IBM arbitration, he becomes ABA president. And his signature accomplishment as ABA president is founding the section on dispute resolution, which is the ADR section of the ABA. And he becomes a big proponent of mediation and alternatives to conventional litigation as a way to resolve disputes. So here we are in the paradigmatic example of resolving disputes through other means. Let me give you one example of what happened in that arbitration that is so unusual. It's very rare, of course, in arbitration for the arbitrator to mediate. But at one point, when we were on a kind of conventional arbitration path, arbitrator Mnookin in particular realized that could lead to years and years of hearings and not really resolve the underlying dispute between the parties, which had to do with how will Fujitsu develop compatible systems in the future. And so he says to the parties, I think this is what the path we're on is a little nuts. I would like, with my other party appointed arbitrator, former railway IT executive that IBM had appointed, we would like to mediate an interim agreement between the parties that would then set the framework for a revised arbitration. So this is a med-arb proceeding, which again is very unusual. I remember a few things about it that are noteworthy. Number one, arbitrator Mnookin in particular was extremely careful to document the parties' agreement that we were allowing him to proceed in this med-arb fashion, and that regardless of what happened in the mediation, he would be deemed to be the arbitrator, and there would be no assertion of conflict, and of course no assertion that this role as mediator was independent with being an arbitrator. In fact, not even independent arbitrator. I should have mentioned clearly that we had appointed Bob Mnookin as our party appointed arbitrator, and IBM had appointed Jack Jones, the railway IT executive, as theirs. So these two party appointed arbitrators are now going to mediate, and then they're going to be neutral arbitrators. It was a fascinating exercise. One of the other things that jumps out at me is that Bob Mnookin was smart enough to have us all in Washington for the mediation phase of this, so that the ensuing agreement could be called the Washington Agreement, which gave it an air of considerable dignity. And sure enough, it put us on a foreshortened dispute resolution path that led to the biggest issues in the case being wrapped up in more or less 2 years instead of the indefinite proceeding that we were enmeshed in.
So here you are, a relatively junior associate at that point, suddenly playing in the major leagues, to say the least. What were the next steps that unfolded in your career?
And so what happened was that this case became the largest case ever in the history of the firm. And I'll never forget the Fujitsu executive turning to Bob Raven at a meeting and saying, "We need more lawyers on this case," which is the opposite of what you usually hear from a client. But IBM, what happened on the IBM side, this is another fascinating little episode. IBM had just, as it was embarking on this intellectual property enforcement campaign, IBM was just coming off of US versus IBM, a nearly, maybe it was 10-year-long antitrust case against the government in which Cravath had represented IBM. And then that had occurred under the administrations previous to the Reagan administration. The Reagan administration comes in and settles the case. And all of a sudden, Cravath has this army of lawyers who've been working on probably their biggest case ever USB IBM. So they have a ton of lawyers to apply to this intellectual property dispute, and really good lawyers. The Fujitsu executive turns to Bob Raymond and says, "We need more lawyers on this case." The upshot was that a very large contingent of really smart people at Morrison and Foerster fell in love with intellectual property law and technology disputes. We decided thereafter to create an intellectual property group. The other thing that has happened along the way is that the United States has taken the system of regional circuit courts, which adjudicated patent disputes, and converted that into something called the Court of Appeals for the Federal Circuit, which is now going to hear all patent appeals with the idea of harmonizing and strengthening the US patent system. That in turn has led to a bigger role for patents in litigation and a bigger role for trial lawyers as opposed to patent lawyers in patent litigation. So just as we're coming off of the biggest part of the Fujitsu IBM arbitration, the patent litigation world is starting to boom. And we saw that wave out there in the ocean and we paddled out to it, and we decided to surf it for the foreseeable future. Along the way, the powers that be in the firm decided to snatch from obscurity this then young partner and my colleague Billy Schwartz on the transactional side and ask us to be co-heads of the new intellectual property group at Morrison and Foerster. And so that is how I converted fully into being a technology, intellectual property, commercial technology disputes lawyer that ultimately ensued.
Initially, I seem to recall, there was some reluctance on the part of disputants in the patent context to engage in arbitration as a way to resolve these questions. And there certainly were a large number of these big name cases in our federal court system. Tell me about your observations in that regard and how alternative dispute resolution, arbitration, mediation has become a bit more of a force in that arena.
I think your observation is correct that companies are quite reluctant to put their crown jewel patent disputes, their mission critical intellectual property claims into the arbitration system in particular. And so when we do arbitrate patent disputes, it's rarely as a result of companies affirmatively deciding, boy, this is the way we should do this. In fact, in a non-trivial number of commercial agreements that have arbitration clauses, patent disputes are carved out of them so that they do not go through the arbitration system. They go off to the relevant district court. There are a few exceptions to that, but I think the generalization still holds, Chuck, that the typical patent case does not go to arbitration. What does go to arbitration are license disputes that may have patent disputes inherent in them. Is this a covered product? For example, where the parties have put an arbitration clause into their license agreement. In fact, along the way in my IP litigation practice, the patent disputes that I handled that we arbitrated were all the result of license agreements that had arbitration clauses. I remember, for example, being in San Diego for an arbitration with Qualcomm, and the small world story being that one of my counterparts at IBM during the IBM Fujitsu dispute became the general counsel of Qualcomm and was the general counsel of Qualcomm by the time this later case arose. So I remember arbitrating a patent dispute involving Qualcomm in which we were trying to show that 24 patents were not infringed by our client's product. So it's in a sense a classic patent dispute lurking in a license agreement dispute.
One muses upon the fact that federal district court judges, particularly in certain areas of the country, have full dockets and all of a sudden comes landing in their lap one of these patent cases. And I appreciate there are some federal judges who have developed an interest in patent litigation, particularly, and figured out how to handle them procedurally. But I'd be interested in your observations about the brain power, the skill set that a judge randomly assigned to a patent case can bring to an intellectual property dispute compared to an arbitrator who probably has more time to devote to the case than a district court judge. And how does that affect the quality of the outcome?
One thing that I have been commenting on as I reflect on the fact that I'm now a dispute resolver rather than a disputant is how much I have newfound respect for federal judges or judges generally. I always respected them a lot, but now that I actually have to write decisions, I see what the task is in front of a dispute resolver, dispute adjudicator. In my practice, I was enormously impressed with the quality of the federal judiciary and their ability to grapple with these cases. It seems very intimidating at first, but it gets broken down into its constituent parts. The Federal Circuit's guidance is more or less consistent now in most areas. So actually figuring out what the law is and what the jury instructions need to be is maybe not as hard as that. But of course, you're absolutely right. I mean, there are potential advantages to arbitration if the arbitration world is able to demonstrate and satisfy the clients that it will reach reliable outcomes in their disputes, adhering to the relevant law as much as a district court that is supervised by a Federal Circuit Court of Appeals adheres to the relevant law. One of the things that came out of the IBM Fujitsu dispute was our realization that the arbitrators can actually be very arbitrary. So I think it's on us to demonstrate that we can really do a great job with these cases. And by a great job, a job that when a party looks at a written decision from the arbitrator goes, you know what, that is actually better than a decision I would have gotten. Just it's a higher quality legal work product than I would have gotten from a federal judge. And then on the case management side, I think that's where we could really star. I think we could figure out, you know, we have such discretion in arbitration in the way we run our cases that if we see opportunities to lance the boil of an issue that's really got the parties at loggerheads and causing all sorts of spinning of wheels and gnashing of teeth, and we could say, you know what, let's tee that up. Let's just get it decided one way or the other. I think we fall into our own ruts too much and our own patterns. I think we should be looking for ways to do that.
Your comment about the supervisory power of an appellate court perhaps provides some measure of confidence in the mind's eye of a client that I'm better off in a federal district court where even if the jury goes crazy, I've at least got some prospects of having another set of eyes look at this issue. The jury system is something I personally happen to be a great believer in, but it has its limits. And particularly in a complicated intellectual property case, it seemed to me that that might be one place where arbitration particularly could shine as fact finders.
I think that's right. And there's another development going on in patent litigation right now that may influence the choice of forum. So with the American Invents Act over a dozen years ago now, the system of challenging patents in the patent office was reformed to make it fairer and more viable. And so a whole industry developed of pursuing what are called inter partes reviews, IPRs, when a patent is asserted. And if done on a timely basis and the judge is otherwise inclined, going to the judge and seeking a stay of the district court litigation while the patent office reevaluates in an adversarial process with expert testimony whether the patent is valid. Very much like an arbitration, except once again, there's Federal Circuit review, but it's not a jury process. And the reason that defendants in particular liked IPRs is that the standard for succeeding in the patent office was lighter on a challenger than in district court. As a matter of exercise of the PTO, the patent office's director's discretion, inter partes reviews have become a vanishing species. The patent office has decided not to institute challenges to patents filed as IPRs, and the Federal Circuit, following the statutory mandate, has decided that these non-institution decisions are, unless somebody figures out a very clever argument that hasn't been tried so far, non-reviewable. So this avenue for a non-jury decision on validity, valuable from the defense standpoint, seems to be going the way of the dodo bird. Maybe that will incline at least defendants to be more inclined to think about arbitrating patent disputes. Well, now you got to think about the plaintiffs. And plaintiffs are very into the jury system, of course, because they get to tell a good story. So the plaintiffs have to now think that something will be better for them in arbitration. And I'm not yet sure what that will, I don't yet see that on the horizon. So we'll just see how this all unfolds. You know, we do get a crack at these cases as mediators. Almost every district court has a mediation deadline in a patent case. They're very hard to settle because of what you pointed to. There's this Federal Circuit out there that can fix things if it goes off the rails. The plaintiffs often see large damage awards. The damages horizon is far bigger than the legal expense in many of these cases, at least the ones that I've been asked to mediate. And so they're challenging to settle because litigation costs, oh yeah, there's litigation costs. But look, we're seeking $100 million. So another $1 million in litigation costs from here.
You had a very satisfying career, it appears. I wonder if you can just reflect a little bit on your work, and particularly in this intellectual property space. What are the things that you found most rewarding, stimulating, and fulfilling out of that?
Boy, it has been a great run. A couple of things. The quality of the clients. So I never had a client that I looked at and went, how can I possibly represent this entity? They were technology and science companies. My career took a turn to a lot of life sciences litigation, and we're talking biotechnology companies founded by premier scientists and investors with a really long-term view, and just really high quality people, whether on the plaintiff or defendant's side. And the in-house lawyers at these companies were also wonderful people who loved the work they were doing in trying to advance the thresholds of science and technology, and they were terrific. Fabulous clients, fabulous subject matter. The cases were just endlessly interesting and intriguing, whether it was the case that you and I worked on, which had to do with portable keyboards and what was a pivot. And we learned a lot about how to make those things small and flat and carryable, or an antibody drug conjugate to cure cancer, artificial Christmas trees. It just ran the gamut. And they were all, I just found them all. I never had a boring case. And then the last thing was the quality of the colleagues. It had the IP bar, my IP colleagues, but also my co-counsel and my adversaries. I just really enjoyed. I really liked them as people. They were interesting and interested. They were great lawyers. So as this field evolved, it attracted a bunch of really good lawyers who were also very interested or maybe trained in science and technology. And I just really grew to adore these people and had great relationships with friends and adversaries. I call this the professional trifecta. Challenging cases with the highest quality clients and the most interesting and satisfying to work with colleagues. It was just great.
Well, there comes a time when you want to start a new chapter in your life. And what caused you to say, I think I'll go pursue this ADR thing for a while? You probably earned the right to go off to a cattle ranch someplace and fly fish.
The timing was really driven by just that sense that I had been litigating for 40 years. A bunch of cases had been resolved, a bunch of clients had been acquired. I had a big pro bono case that I wanted to resolve before I left practice, and I was able to see that on the horizon. And I wanted to start something new when I was young enough that it could itself be a meaningful. One of my colleagues gave me that advice. Don't wait too long if you're thinking of doing this. And it was really great advice. And I'd always been thinking about this as a possibility. I had laid some groundwork along the way, and it just felt like the time was right. Circumstances called for it.
So what are the aspects of the ADR world that are putting that smile on your face today?
Well, it's similar. I very much enjoy my colleagues. I especially enjoy my colleagues at JAMS. It's a really interesting group, and JAMS does a good job of giving us opportunities to interact, even if the practice itself is kind of a solo practice. I very much enjoy the lawyers and their clients and the subject matters they bring. And I enjoy the challenges of actually having to work through and figure out what is the right answer. Even if it's in a mediation context, I have to figure out something about strength and weaknesses of claims. But in an arbitration context, which is just as it happens, my docket right now is heavily arbitration focused. I've really got to work through some very nitty gritty issues in the face of sometimes obscure court decisions. And it's a very interesting process. And then I think as I mentioned earlier, I'm very interested in case management and how we can use this process to resolve disputes efficiently. As I was leaving law school, I thought the litigation process was crazy. So I went into a business practice. And what I was lurking in that assessment was, boy, this is just a really inefficient way, this US litigation process with claims and counterclaims and discovery motions and then summary judgment motions and then jury trials and then judgment out of a matter of law motions and then appeals. I mean, if you think about it, it's quite an architecture we've developed here. So now I get a chance to think about, okay, how can we do this differently? I have all authority. There is no jury. There is no appellate process. What's the best way I have the rules and I have litigant expectations, but let's see if we can do this smartly. So far, it seems to be off to a good start.
I'm glad you mentioned just a few minutes ago your pro bono case, because one of the things that I wanted to ask you about was taking you back to law school and this international human rights project work that you got involved in, which says a great deal to me about who you are and what you're made up of. Tell us a little bit more about that work and what importance it's had to you in your professional career.
Thanks, Chuck. It's a great topic. So this is the Allard K. Lowenstein International Human Rights Law Project at Yale Law School, which thrives to this day. I founded it with a now, sadly, died at a young age, a friend named Ken Schwartz at the law school. Ken himself was a friend of Allard Lowenstein. Allard Lowenstein was an early anti-war Democrat in Massachusetts. And he was a hero to the anti-war movement for the way he took his legal training and converted it to advocacy. And he was a Yale Law graduate. So we took Lowenstein's then recent death and used that as the hallmark for this International Human Rights Law Project. At the time, two things had happened that were significant. One, Jimmy Carter had just been president, and he had made human rights a hallmark of US foreign policy in a way that no one had done before. And the courts were deciding cases against aliens under the Alien Tort Act, allowing victims of human rights abuses in foreign countries to sue their torturers in US court. There was a famous case called Filartiga that had allowed such a claim to go forward. That line of cases ended up being diminished over time by the Supreme Court, but at the time it was quite a thing. So Ken and I, thinking about, okay, what can we do? We looked around in the law school and we said, you know what, Yale Law School doesn't have really very much about international matters or human rights. Let's try this out. And so we created this International Human Rights Law Project. And the way the world works, it's just so interesting. We hosted a conference that brought people in from around the world to talk about the topic of human rights and national security. And how do they intersect, and how does one potentially interfere with or reinforce the other? We had fabulous speakers, and it was kind of a meaningful event. So when I went into practice, one reason I chose Morrison and Foerster was that it had a well-established reputation for doing terrific pro bono work. And while I did not carry on international human rights law work, I did have a great series of pro bono cases across my time there, and it was a really valuable part of my career.
If somebody goes to LinkedIn today, they're going to see the name Adam Grant associated with Mike Jacobs. What is the fact that Adam Grant is mentioned on your LinkedIn page say about you?
In the mid-90s, I was asked to become managing partner for operations of the firm. It was a time of crisis. We were the country was coming off of a recession. The legal profession was coming off of a recession, and Morrison and Foerster was coming off of a recession. And so I was asked to be the second in command and to deal with some particularly gnarly problems the firm faced. So I got a quick dose of management training, and helped by our then chief administrative officer, a very capable woman named Penelope Douglas, who very quickly made me realize that the art of management is an extremely noble pursuit. When you are a manager, you have people under you who are spending a majority of their waking hours with you, under you, and their happiness in life turns critically on your ability successfully to manage them and to make their work fulfilling and satisfying and empowering, and to minimize disputes around them. And so I became a fan of the management literature. It's episodically useful in terms of its practical application, but I really enjoy Adam Grant and think that his writing, among most of them, is the most well-grounded and useful.
Mike, a viewer of this interview, I think, could easily come to the conclusion that with people like you migrating into the arbitration and mediation practice, the future looks pretty bright. I'd be interested, though, in having your perspectives. What do you see, not only for yourself, but for this profession going forward?
What I have tried to do as I've made this switch from practice to neutral work is to be the kind of neutral I wanted when I was in practice. And I think if we are able to do that, let's listen really hard to whatever the critiques are of the EDR world on the part of the people who hire us. Stepping out of our little niche right now, I think we can observe in society at large that institutions that aren't continually evaluating how they are perceived and what they are delivering fall into disrepute. So my urging to our field is, let's listen really hard to what people are worried about. It's like getting decisions out quickly. It's making sure they're well reasoned and grounded in the facts and law. It's being very well prepared, whether you're a mediator or an arbitrator. After all, they're paying for our time. It's never, and this is my most emphatic feeling, never giving the litigants the impression that you are milking the case. Because unlike federal judges who are paid on a salary, we are paid by the hour. So we have to counteract the feeling that a litigant might have based on how we are arguably incented to maximize our work. And so I think we need to, because the incentives are perceived to work that way, I think it's doubly incumbent on us to make sure that we don't look to the litigants like we are acting in our financial self-interest as we make case management decisions. So that's my riff. It's a little more pointed, I think, than you might hear from most in our field, but I came into this field with some pretty strong feelings about what we can contribute by way of efficient dispute resolution, but also what some of the perceptions are out there that might get in our, where we might be getting in our own way.
I meant what I said, Mike. I really do think a reasonable conclusion listening to this interview would be that this area of the profession has a very bright future. And you highlight some important things for all of us who are in the neutral game to keep our eyes focused on, to listen, to be responsive to what the market is really saying to us. But I'm very optimistic. I'm delighted to see people like you transitioning your practice into the kind of work that I personally found so rewarding. And I want to thank you very much for taking the time to be with us today. I know that the people who turn on this interview and listen to a few minutes of Mike Jacobs are going to be richly rewarded. And thank you for making all that possible.
Thank you, Chuck. One of the joys of this phase of life is renewing old acquaintanceships and friendships from prior experiences, and it's great to be with you on this call.
Happiest of days.
You too.